This is part 4 of company law problems and solution. The first topic is meeting of board. So the problem: examine with reference to the provisions of the Companies Act 2013 whether notice of a board meeting is required to be sent to the following persons. Therefore, the first one is an interested director. So here an interested director under section 173 subclause 3, once again section 173 subclause 3 of Companies Act 2013 makes it mandatory for every director to be given proper notice of every board meeting. It is immaterial whether a director is interested or not. In case of an interested director, notice must be given to him even though he is precluded from voting at the meeting on the business to be transacted. The next one is with respect to a director who has expressed his inability to attend a particular board meeting. In terms of section 173 subclause 3, even if a director states that he will not be able to attend the next board meeting, notice must be given to that director. The next category is a director who has gone abroad for less than 3 months. A director who has gone abroad is still a director. Therefore, he is entitled to receive notice of board meeting during his stay abroad. The Companies Act 2013 allows delivery of notice of meeting by electronic means also. This is important because the Companies Act 2013 permits a director to participate in a meeting by video conferencing or any other audio-visual means. Now, another problem. The chairman of Greenhouse Limited convened a board meeting and 2 weeks' notice was served on all directors of the company. 2 of the independent directors on the board objected on the grounds that no proper agenda for the meeting was circulated. So the solution: according to section 173 subclause 3 of the Companies Act 2013, a meeting of the board shall be called by giving not less than 7-day notice in writing to every director at his address registered with the company, and such notice shall be sent by hand delivery or by post or by electronic means. The Companies Act 2013 does not specifically provide for sending agenda along with the notice of the meeting. However, generally as a good secretarial practice, the notice is accompanied with the agenda of the meeting. The contention of the independent directors objecting on the ground that no agenda for the meeting was circulated does not hold good. Further, the chairman of the Greenhouse Limited was convened the board meeting by serving a 2-week notice, that is more than 7 days, so the meeting shall be valid. Another problem: the board of directors of ABC Limited met thrice in the year 2014, and the 4th meeting, though called, could not be held for want of quorum. Examine with the reference to the relevant provisions of the Companies Act 2013 whether any provisions of the Companies Act 2013 have been contravened. In terms of section 173 subclause 1, once again, section 173 subclause 1 of the Companies Act 2013, a company must hold a minimum number of 4 meetings every year of its board of directors in such a manner that not more than 120 days shall intervene between the 2 consecutive meetings of the board. The proviso to this subsection, that is section 173 subclause 1 proviso, provides that the central government may by notification direct that these provisions will not apply in relation to any class or description of companies, or may apply subject to such exceptions, modifications or condition as may be specified in the notification. Under section 174 subclause 4 of the Companies Act 2013, where a meeting of the board could not be held for want of quorum, then unless the articles of the company otherwise provide, the meeting shall automatically stand adjourned to the same day at the same time and the place in the next week, or if that day is a national holiday, till the next succeeding day, which is not a national holiday, at the same time and place. From the above provisions, in case a meeting is adjourned, the violation under section 173 subclause 1 does not arise, as the meeting was started well in time but could not close due to the want of quorum. The holding of the adjourned meeting, though in the next year will be treated as continuation of the fourth meeting of the previous year and will therefore not count in the meetings held in the next year but in the previous year. The next problem. Analyze and advise with reference to the provisions of the Companies Act 2013 the following situations. There are 9 directors in a company, and out of which 2 offices of the directors have fallen vacant. What will be the quorum of the board meeting? According to the section 174 clause 1, section 174 clause 1 of the Companies Act 2013, quorum is 1/3 of the total strength of board. Any fraction contained in the said 1/3 being rounded as 1 or 2 directors, whichever is higher. The total strength is to be derived after deducting the number of directors whose offices are vacant. The total number of directors is 9 and 2 offices of the directors have fallen vacant. Therefore, 3 directors would constitute the quorum for the board meeting. Now, the next problem. Some urgent items are left over in the agenda of board meeting, which concluded and decision cannot be deferred till its next meeting. Advise the company about how the resolution shall be passed now. So, resolution may be passed in respect of board approvals in one of the 2 ways, either at the board meetings or by circulation. The items which could not be concluded and decided at the board meetings, if cannot be deferred till the next meeting, may be passed by circulation, provided they do not include such items as are required to be passed only at the meeting of the directors under section 179 subclause 3 of the Companies Act. Section 179 subclause 3 of the Companies Act 2013. In order to pass any resolution of the board by the circulation, the following steps must be taken and completed as laid down in section 175 subclause 1. So, the first one, the draft of the proposed resolution must be circulated along with all relevant and necessary papers. Second, the above documents must be delivered to all the directors, members of the committee, as the case may be, all their addresses registered with the company in India. The third, the document must be delivered by hand delivery or by post or by courier or through such electronic means as may be prescribed. The fourth one, the resolution must be approved by a majority of the directors or members who are entitled to vote on the resolution. The fifth one, there must not be any objection from not less than 1/3 of the total number of directors of the company for the time being, requiring that such resolution under circulation must be decided at a meeting. The resolution so passed shall be noted at a subsequent meeting of the board or the committee thereof and be made part of minutes of such meeting. So, the 5 categories is: the draft of the proposed resolution must be circulated along with all relevant and necessary papers. The second one, the above documents must be delivered to all the directors, the members or the committee, as the case may be, all their addresses registered with the company in India. Now, the third one, the documents must be delivered by hand delivery or by post or by courier or through such electronic means as may be prescribed. The fourth one, the resolution must be approved by a majority of the directors or members who are entitled to vote on the resolution. Now, the final one, the fifth one, there must not be any objection from not less than 1/3 of the total number of directors of the company for the time being, requiring that such resolution under the circulation must be decided at a meeting. Now, the next problem. ASP Limited, a listed company, secured residential accommodation for the use of its managing director by entering into a lease agreement with the landlord. As per the terms of the agreement, ASP Limited deposited a sum of 10 lakh as rental advance with landlord. Referring to the provisions of the Companies Act 2013, decide whether the said deposit amount be considered as a loan given to the managing director. According to section 185, subclause 1, Section 185, Subclause 1 of the Companies Act 2013, no company shall directly or indirectly advance any loan, including any loan represented by a book debt, to or give any guarantee or provide any security in connection with any loan taken by A. any director of the company or of company which is its holding company, or any partner or relative of any such director, or B. any firm which any such director or relative is a partner. In the given problem, ASP Limited has secured residential accommodation for which the company has deposited 10 lakh of rental advance for use of its managing director. The company in any way has not advanced any amount to the managing director directly or indirectly. Further, in the company and not the MD who has entered into the lease agreement. The disposal of the said accommodation is at the hands of the company. Hence, in the light of the facts of the question, the provisions of law, the said deposit amount cannot be considered as a loan given to the managing director. The next question is from the section of promoters. The problem: those 6 out of the 7 signatures of the Memorandum of Association were forged. The company was registered and the certificate of incorporation issued. Can the registration of the company be challenged subsequently on the ground of forged signature? So the exact same question we already discussed. That was in under section 3 3 capital A. When we discussed section 3 capital A in part 2, we already discussed this question. Now, as per Companies Act 2013, certificate of incorporation is not conclusive proof of everything prior to the incorporation being in order. Now, validity of certificate of incorporation. Certificate of incorporation is a legal evidence with regard to the registration and formation of a company. Section 7, Subclause 6 of the Companies Act 2013 provides that where at any time after the incorporation of a company, it is proved that the company has been got incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by fraudulent action, the promoters, the persons named as the first directors of the company, and the persons making declaration shall each be liable for action under section 447 of the Companies Act. Section 447, liable under section 447 of Companies Act. Now, section 7, subclause 7 of the Act provides that where a company has been got incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by fraudulent action, the tribunal may 1. Pass such order as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles, in public interest or in the interest of the company and its members and creditors. Or 2. Direct that liability of the members shall be unlimited. Or 3. Direct removal of the name of the company from the register of companies. Or 4. Pass an order of the winding up of the company. Or 5. Pass such other orders as it may deem fit. Now towards the next problem. The promoters of your company, incorporated on 9th April 2014, had entered into a contract with M on 8th March 2014 for the supply of goods. After incorporation, your company does not want to proceed with the contract. As a company secretary, advise the management of your company. Pre-incorporation contracts in general are void ab initio and hence not binding on the company. However, under Section 19 Subclause E of the Specific Relief Act 1963, the party to the contract can enforce the contract against the company if the company had adopted the same after incorporation and the contract is warranted by terms of incorporation. Thus, unless the company adopts the contract, the other party cannot enforce the same against the company. However, promoters can be held personally liable. Now the next problem. All the 7 signatures on a memorandum of association were forged by a person and certificate of incorporation was duly obtained. Is the certificate of incorporation valid? Explain. The promoters, the persons named as the first directors of the company, and the person making declaration shall each be liable for the action under section 447. Now, few friends purchased a property. Later, they promoted a company and sold the property to the company at a huge profit. Can the company recover this profit from the promoters? Now, the company can recover the profit from the promoters as this is not disclosed by them. They should have disclosed their interest in this transaction to the company before the sale was concluded. Now, the Companies Act 2013 defines the term promoter under Section 2, subclause 69, which means a person A who has been named as such in prospectus or is identified by the company in the annual return referred to in Section 92, or B who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, or C in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. This shall, however, not apply to a person who is acting merely in a professional capacity. Now, the liabilities of a promoter. First one, non-disclosure of secret profit. That is what is discussed in the present problem. So, that is the first liability of the promoter. In a case a promoter fails to make full disclosure of his dealings and profit made in promoting the company, he can be compelled by the company to hand over such secret profit. The company can also sue for the rescission of the contract of sale by the promoter where the promoter has not disclosed his interest therein. The second liability is non-adoption of preliminary contract. If a promoter enter into a contract on behalf of the company before the company was actually incorporated, he may be held personally liable for non-adoption of those contracts by the company, provided he has purported to act as an agent and the non-existence of the company was known to both the parties. The third liability is fraud in the promotion of the company. Under fraud in the promotion of the company, the first one, if a promoter furnishes any false or incorrect particulars of any information or suppresses any material information of which he is aware in any of the documents filed with the registrar in relation to the registration of the company, he shall be liable for action under section 447. The second one, where it is found that any fraud has been committed in promoting or forming a company, the tribunal may order investigation against the promoters, any other directors or officer of the company involved in such fraudulent activities. That is discussed in section 282. And the third, a company may proceed against a promoter where the promoter has wrongfully obtained possession of any property, including cash of the company, or wrongfully withholds it or knowingly applies it for the purpose other than expressed or directed in the articles and authorized by the act. That is discussed under section 452. Now, the fourth liability of a promoter is omission in the prospectus. Prospectus issued by a company must have the contents as laid down in section 26 of the company. That is section 26 of the Companies Act 2013. In case of omission of facts, the promoter shall become liable to be punishable with imprisonment for a term which may extend to 3 years or a fine from 50,000 to 3 lakh or both. That is discussed in section 26 subclause 9. That is omission in the prospectus. Now, the last and the final liability of a promoter is misrepresentation in the prospectus. A promoter is liable for any untrue statement in the prospectus to a person who has subscribed for any shares or debentures on faith of the prospectus. Such a person may sue the promoter for compensation for any loss or damage sustained by him. That is discussed in section 35. So the next topic we are going to discuss is about prospectus, which is very important, and we have many problems with respect to prospectus. So that will be discussed in the next part. That is part 5 of this session. Thank you for listening and stay tuned. Bye.